I call the honourable member Dennis O'Rourke.
Mr Speaker, New Zealand First supports this huge 1,238-page bill to the Select Committee stage for scrutiny. Sorry? I think it's 1,238, but we could debate that at another time. Until then, anyway, as you can see, it should make a good doorstop. I would have to disagree, by the way, with the Attorney-General about the old TV program featuring Mr Haddock with Alistair Sim as the judge. Haddock may have been an expert vexatious litigant, but I got a lot of my legal education from him. Damn sight more. Well, if it shows, then it shows that it was a good TV program because it was good quality stuff. Better than some of the incompetent law lecturers I had to endure in those days. But anyway, Mr Speaker, the bill has a lot of merit. It implements the government's response to the Law Commission's report and accepts 71 of the 89 Law Commission recommendations, and they fall into 4 areas. Firstly, the court structure and legislation. Secondly, judges' appointments and how they operate. Thirdly, court administration. And fourthly, non-party participants and, of course, vexatious litigants. Yes. And, Mr Speaker, these revisions are generally welcome and will be welcomed by the profession. They're needed to update the courts using 21st century technology, to allow better use of resources and to improve administration. And there's a need to make the courts more people-friendly, more accessible, more understandable, and especially more transparent. Part 1 repeals and replaces the Supreme Court Act 2003 and, more particularly, the Judicature Act 1908. And it's high time for that. The old legislation was outdated and rather Dickensian. The new court is intended to be more people-centred, modern and accessible by improving transparency, flexibility and relevance of senior courts. And those are very good objectives. Some of the main features of Part 1 are the creation of a single statute for the senior courts, and also it will streamline the current arrangements as to who can be appointed as non-permanent judges, including limiting appointment to former or current judges rather than directly from the bar, and generally setting more consistent appointment periods and age limits across the courts. Those changes will be very welcome. Existing ways of appointing judges otherwise remain, but published guidelines and protocols are sorely needed, and I see that these are now proposed. Similarly, the bill codifies restrictions on judges' other appointments and employment and issues relating to potential pecuniary conflicts of interest, and there is quite a lot of public pressure for that as well. The bill establishes a judicial panel in the High Court from which judges can be allocated to hear specified types of commercial cases, and that will match recognised judicial expertise to cases where parties wish to have a panel judge assigned. That's going to ensure better use of judges' expertise, and again is a very welcome new provision. The bill will also work towards more transparency, and that's particularly welcome. The judiciary is to publish information relating to the delivery of reserve judgments, recusal from cases, the suitability of judges holding employment or other office, and all final written judgments, unless there is good reason not to do so. And the Attorney-General is to publish the process that he or she follows when making judicial appointments, and the public will welcome that. Part 2 deals with and replaces the District Courts Act 1947 and establishes a unitary district court, and that is also to be more people-centred, modern and accessible. The bill reconstitutes the district courts as a single court with divisions for the family court, a youth court and a disputes tribunal. It increases the monetary limit of the court's civil jurisdiction from $200,000 to $350,000, and I might say that is well overdue. It also provides the District Court with the power to stop vexatious civil litigation, and there are to be the same transparency requirements as I've already mentioned for the senior courts. Part 4 implements the government's response to the Law Commission's report on aspects of damages, the award of interest on money claims, and that is very long overdue and will be particularly welcomed by the profession. It produces a single statutory system for the award of interest. It will provide a greater degree of certainty for the court in awarding interest on money claims, and it will promote clarity, simplicity, consistency, and is likely to deter, again, vexatious litigation. These are very good provisions and ought to be supported by us all. But Part 5 is also important. It provides for the legislation to enable and govern the use of electronic technology in court and tribunal proceedings while protecting access to justice for all people. This is very important, and people expect these days for the courts to be up to date in terms of modern technology. I only regret that the recent e-bench failure at stage 3, after the expenditure, I understand, of something like $18 million, is quite unacceptable, and it's an area in which the government must do much better. Part 6 amends 17 other statutes. There are amendments to the specialist courts legislation covering the Employment Court, the Environment Court, the Maryland Court, by applying a number of provisions contained in Parts 1 and 2, as mentioned, to the specialist courts. And there is to be an amendment of the Arbitration Act 1996 as well, to replace the definition of an arbitral tribunal and to permit the Minister of Justice to appoint a body to resolve certain matters relating to an arbitration. I think these are very welcome changes as well. Mr. Speaker, overall New Zealand First welcomes the bill and will vote for it to go to the Select Committee stage, where we will all need to spend a great deal of time ploughing through that huge statute. And I think people who are not on that Select Committee will be glad that they aren't. Well, of course you will, Mr. Goff. We look forward in any event, Mr. Speaker, to scrutinising the bill at that stage in detail and to the report back to the House, but I'm sure in the end this will be pretty much of a very important leap forward for the court and justice system in New Zealand.
I call the honourable member.